This conference will now be recorded.
All right, thanks again for joining us. I'm pleased to introduce Dr. Richard Darden, an ecologist with the Federal Highway Administration, Office of Planning and Environmental Review, with over 30 years of experience in the environmental permitting and NEPA world. At Federal Highway, Richard serves as the headquarters subject matter expert for wetlands and waters of the U.S. and works closely with the National Transportation Liaisons at the Army Corps of Engineers, EPA, and U.S. Coast Guard on programmatic policy and guidance topics, as well as project-specific reviews. Richard's previous experience includes positions as a regulatory project manager in the Corps of Engineers in Charleston and the Alaska districts, as well as the program manager at Corps of Engineers headquarters. In these positions, Richard was principally involved in regulatory NEPA compliance, one federal decision, and other infrastructure-related efforts, as well as leading the Charleston District jurisdiction practices since the 2006 Supreme Court opinions in Rapanos, Carabel, and continuing through the 2020 Navigable Waters Protection Rule. Richard has managed lead and cooperating agency environmental impact statement preparation for major mining, nuclear, and coal-fired generation, highway and rail terminal transportation, pipelines, and mixed-use developments. Richard earned a Bachelor of Science in Biology from Arkansas Tech University, a Master of Science in Zoology from Northwestern State University, and a PhD in Biology from the University of Southern Mississippi. We're very happy to have you with us today, Richard. Thank you so much.
Yeah, so actually, the thanks to y'all for inviting me and devoting an hour of your time to a topic that's quite near and dear to my heart, and hopefully everyone who's joined. So the topic is literally simply an update on my part of the current status of the definition of waters of the United States. And as you can see, just literally in the title, that the definition has evidently been revised, but then a little tongue in cheek there, I added that it's also been amended after being revised. And so I'll flesh all that out for you, hopefully in a very clear and accurate way. So you either may have heard the phrase waters of the United States. You may have heard WOS, W-O-U-S, Waters of the U.S., or the acronym that seems to be most in vogue right now, WOTUS, Waters of the United States. And so what we'll be talking about is really the current status of the so-called 2023 WOTUS rule. So here we go. And I've put together a slide deck, which is I think about 20 slides. And so it's not overwhelmingly slide heavy, but want to try to follow this agenda or outline. We want to give some background on waters of the U.S., which includes some of the legal framework behind the development of the rule and where we are now with the final amended rule. And so then we'll cover in kind of explicit detail what does the 2023 WOTUS rule provide in terms of jurisdiction for waters that are waters of the U.S. And then importantly and appropriately, there are exclusions included in the rule that apply to certain kinds of waters. And so we'll cover those. Particularly, we'll cover things that involve transportation and stormwater. This group hopefully will agree with that focus. And then hopefully we'll have time in the end, and I think we should, for discussion. This is a topic that I think gets everyone's attention, and everybody, I think, often has things that they want to observe or interject. So we'll have time for that, I think. Okie doke. Well, so just by way of background and framework, the waters of the United States and the Clean Water Act, kind of the federal statute that carries that phrase, they establish literally, as you can see here, the geographic scope of the federal government's jurisdiction on waters. But importantly, you may know or you may not know that the Clean Water Act itself doesn't actually define what are the waters of the United States, and that was left to the agencies being EPA and Department of the Army. And so both of those agencies have defined that in their regulations for many years now. And so I'll promise not to give you a whole bunch of regulatory citation, but here for completeness and maybe future reference, the citations for the Corps of Engineers, which is Department of the Army, and EPA are given there for you. And so really context, WOTUS matters to us all and in a variety of different ways. So literally there's a number of important sections in the Clean Water Act, and we've pulled out here consistent with information presented to us by the EPA and Army in some of their webinars. Let me make a quick aside as well that'll frame things up. What I'm going to do is provide information that is consistent with what EPA has provided to federal agencies and the public so far. I don't want to read in things that haven't been provided by EPA. So that inherently may mean that there are some specifics of implementation that will come to us in time from the Corps of Engineers and perhaps EPA. So this is the quote unquote party line from EPA, and so much of what you see, if you've been in any EPA webinars, you may recognize some of this information because I want to keep it very consistent. So anyway, so different parts of the Clean Water Act refer variously to waters of the U.S. or navigable waters, including territorial seas. And so in the water quality area, you see 303, water quality standards, spill programs, the certification program under 401, which can be administered by EPA themselves or by states and even tribes. So that's a well-known program. And then 402, the pollutant discharge permitting program. Stormwater folks are very, very familiar. And then the 404 authority that is designated to the Corps of Engineers, discharge of dredge or fill material. So the Clean Water Act has these numerous sections that all rely on the definition and understanding of what are the waters of the United States. So that's just background. Sorry about air conditioning unit. So just a little bit of background, and I don't want to beat this into too much detail, partly because I'm not an attorney and I shouldn't be trusted with too much legal depth. But I do want to take your mind back to the fact that the definition of waters of the United States has undergone numerous legal reviews, legal challenges, court rulings around the country and including the Supreme Court for many years. And we have had different rules proposed, put in place, and then vacated, associated with past administrations. And so the WOTUS rule, the 2023 WOTUS rule, has come to us during the Biden administration. And so I don't want to go into the real depth on the table that I put together here, but I did want to say that you may recall that during 2021, the Navigable Waters Protection Rule, which came to us in 2020, was vacated by the courts. And at that point, EPA and Army began their work on a proposed WOTUS rule, and so that kicked off in 2021. So ultimately, that was finalized, and then legal challenges began in different places in the country. And so now, just jumping ahead, what that brings us to in terms of current status is that the WOTUS rule is in place and being implemented in part of the country. In the box that I've made on the right-hand side, you can see a column there that shows you which states are using the 2023 WOTUS rule, and then recognizing that some states, 27 in fact, are still being regulated using what's called pre-2015 regime, which is the 1986 regs, consistent with Supreme Court opinions since '86. And so we'll see a bit more about that, but focusing again on WOTUS. So details that come along. You may not have noticed on the previous table that in January of 2023, the WOTUS rule became effective. And then in May 25, a very important case in front of the Supreme Court was ruled on. That case was called Sackett versus EPA. And in the Sackett ruling, the Supreme Court literally invalidated parts of the 2023 WOTUS rule, but it also invalidated elements of the pre-2015 regulation. And so that had to be dealt with. EPA immediately at that time announced their intent to amend the very fresh 2023 WOTUS rule and announced their target date was going to be September the 1st. I think they're pleased with themselves that they actually signed the rule a day or two before September 1st. On August 29, you see the big bold type there to let you see current status. The amended rule, which would be conforming with the Sackett decision, the Sackett ruling, was signed on August 29 and was published in the Federal Register a little bit later on the 8th of September. And it became effective that exact day. So again, we have the WOTUS rule being implemented in 23 states. We have the pre-2015 regulations being implemented in the remaining 27 states. And in each case, those are presumably consistent with prior Supreme Court rulings, including the very fresh Sackett ruling. So that's kind of background. And then just if you're a visual person, I kind of am, this map that was actually put together by EPA, which they call the operative definition map, the OpDef map, shows you in two different colors those states which are following the new 2023 rule, they're in green, and the states that are still following the pre-2015 regime pending resolution of some of the court cases that I'm not speaking about today. So purple or lavender and limey green. So there's your coverage map. And so what I want to do now is go right into the actual waters of the U.S. Regulation as it stands now, consistent with Sackett. And so it's in three parts, as the rule typically has been for many years. It's got paragraphs A, paragraph B, and paragraph C. So paragraph A are what waters are jurisdictional, and paragraph B is the exclusions to coverage as waters of the U.S. And then C is a handful of definitions which are helpful to have as you understand the rule. So we'll take those in order: jurisdictional waters, then exclusions, and then round out with a couple of definitions. And so the one thing that one has to get comfortable with, and I guess I sort of apologize for, is that we tend to refer to various categories of water by their letter and their subparagraph notation, A1, A2, A3, etc. And so you end up hearing people use that notation, an A1 water or an A3 water. I'll try to flesh out what those are each time I mention it, but I apologize, I guess, if I say an A3 water and it doesn't tell you, oh, that's tributaries. So anyway, hopefully for the rest of the hour you can be comfortable with A1 through A5 as categories of water. So then in the exclusions, since they're in paragraph B, they all have similar notation, B1 through B8 exclusions. And practitioners who are steeped in all of this will often talk to each other about, oh, hey, here's a B8 exclusion or a B3 exclusion, ditches. So that's that notation. And then definitions. The definitions are in paragraph C, so they're 1 through 6. And then the last thing to let you know, and I hope this is helpful, I think it is, when the WOTUS rule was first provided to us in January of 2023. It included everything that you see here on the screen. And then when the rule was amended on September the 1st, let's just use that date, in the beginning of September, some stuff got changed to be consistent with the Sackett ruling. Some stuff got eliminated. And so what I've done is to show you in red font things that got changed from the original WOTUS rule to the conforming amended revised definition of waters. Those are in red. And then finally, there's some stuff that's completely shown in strikeout because they're things that not only got amended, they got eliminated. And so as we get to those various categories where there were changes, you'll see that in red font again, and I'll make it clear. So this is the framework of the waters of the U.S. definition, and we'll walk through it. So the so-called A1 waters, these are our absolutely navigable water category, the traditional navigable waters, including the territorial seas, as well as interstate waters. And so these are waters which really are navigable for the purposes of interstate or foreign commerce. And this can be not only currently navigable, but perhaps those that were historically navigable and could be made navigable again with minor alteration. And then, as you probably know, any waters literally that are tidal, subject to the ebb and flow of the tide, are automatically considered traditional navigable waters and navigable waters. You probably know that these waters are also subject to Rivers and Harbors Act jurisdiction under Section 10 at the Corps of Engineers. And so that gives you a little bit of connectivity between Clean Water Act and Rivers and Harbors Act. The territorial seas, I don't think anyone has ever challenged the jurisdiction that the EPA and Army have on the territorial seas. But these are waters that are off the coast, extending 3 miles offshore. And then the part that we need to speak a little bit about is the part that used to be in a different category, but it's now part of A1. It's called interstate waters. These are waters that sit on or cross a state boundary. I spent a lot of time in South Carolina, so waters that cross the state boundary between North Carolina and South Carolina typically would be considered interstate waters, and it makes them jurisdictional by definition as A1 waters. And what I want to call your attention to is that originally this category included lakes, ponds, and wetlands, but as you see, wetlands was struck from their designation as interstate waters when they cross a state boundary. And so wetlands can no longer be an interstate water. So that's an important thing to understand in the conforming, amended definition. For rivers and streams, it's important to note that only the stream reach that is of the same order as the order, as the stream order that's crossing the state line is part of it. You don't pull in other stream reaches, either upstream or downstream, from that state line as part of the interstate water portion. So one very long river may have a reach crossing the state line that's considered interstate waters. The rest of that stream would be jurisdictional in another category, or perhaps not at all. So that's A1 waters, relatively unchanged over many years and relatively unchanged by the Supreme Court rulings in Sackett, except for that wetland piece that we mentioned. I should have shown you this little diagram earlier that I brought forward. This is just literally showing you a hypothetical state boundary, horizontal black line. And you can see that stream reaches in the stream water network graphic are crossing a state line and therefore would be considered interstate waters. Okie doke. So category 2, A2, are what are called impoundments of what would otherwise be recognized as waters of the U.S. And so streams that become impounded to create literally an impoundment reservoir, if you will, are categorized in this category of A2 impoundments, if they otherwise would have met the definition of waters of the U.S. Any stream that would have never met the definition of water of the U.S. May have an impoundment on it, but it wouldn't necessarily be an A2 impoundment. So that was my verbal way of telling you what these subparagraphs down here say. I don't think that there's a lot of question about the jurisdictional status of impoundments on waterways that are recognized already as waters of the U.S. And so just to let you know that A1 and A2 are standalone categories that are jurisdictional waters. And we've seen, as you can tell here, no change to this category because of the Sackett ruling. Category A3, category of water A3 are the tributaries. Okay, and these literally, importantly, are tributaries that flow either to A1 waters themselves, they flow to the navigable waters of the U.S., or they flow to an impoundment that then ultimately would also flow downstream to a water of the U.S. So A3 tributaries are tributaries to A1 or A2 waters, and hopefully that logic makes sense to you. It's important to note that tributaries certainly can be entirely natural. They may be historically natural but man-altered, or they might be entirely man-made. And these are linear features that flow either directly into A1 or A2 waters, or maybe indirectly through another tributary, in a network of stream flow. And so that's probably easy enough to absorb and understand. Recognize also that the category of tributaries can actually also include things that you don't think of as linear features, like lakes and ponds and impoundments, because they have outfalls that actually are flowing downstream to A1 or A2 waters. And then importantly, tributaries can include things like ditches and canals when the ditch or canal actually meets the definition of tributary. And that's based typically on flow, the duration of flow. And so jurisdictional tributaries must, in order to be an A3 water in jurisdictional, they must meet what's called the relatively permanent standard. Excuse me. And so now I want to maybe flesh out a little bit about what it means to meet the relatively permanent standard, because it's very important. So a water meets the relatively permanent standard when it is permanently standing water or continuously flowing water that has that downstream connection to the A1 waters, either directly or indirectly. But also, if you'll note in this first paragraph here, waters with a continuous surface connection to such relatively permanent waters also meet the relatively permanent standard. And so I want to call your attention to some elements on this graphic. This is not the best graphic in the world, but it is the graphic that has been used by EPA to demonstrate a couple of things. And so I want to use the same one, even though it's a little bit difficult maybe to pick up some of the font. So here's a graphic of various types of waters, and if you'll note at the very kind of lower portion, middle to left, there is the ocean and an estuary. These are navigable and fact waters. They're subject to the ebb and flow of the tide, and on that basis, they're A1 waters. I added A1 into the graphic here to give you a sense of what category of water we're talking about here. And then added this red bar here to show you that at this point in the river system, you're at the head of tide. This is the upper limit of tidal influence of tidal exchange. And so we have the edge of what is estuarine or ocean, and that would be a Section 10 boundary. But above that, we still have a very, very clearly navigable river section, and thus still an A1 water because of its navigability, not because it's ebb and flow of the tide. And then finally, upstream of that, you see that the river becomes less navigable, but still perennial in flow based on the notation as a dark continuous line. Thanks to USGS for the notation for many, many years on our maps that we all recognize. So a solid black line is perennial. And that perennial flow continues upstream until you hit stream reaches that have less than perennial flow. So you can kind of see that on the map here. So looking back at the definition of relatively permanent standard, standing or continuously flowing waters connected to A1 waters meet the relatively permanent standard. So I circled perennial stream there, brought an arrow over to show you that perennial stream. That is continuously flowing, directly connected to A1 waters, and thus clearly meets the relatively permanent standard. So that's kind of a show of what it means to meet that relatively permanent standard. All the Supreme Court justices agree that that is waters of the United States under Category A3. And then in terms of other waters that are non-linear waters, wetland waters, there's another way that they end up meeting that standard, and that is waters that have a continuous surface connection to relatively permanent waters that ultimately flow to A1 waters. And so here we see headwater wetlands depicted as continuous uninterrupted connection to a relatively permanent water, clearly meeting that continuous surface connection concept. Let me back up, sorry. On the graphic, you notice there are other wetlands that I'm not calling out for the moment, just because we don't have time to talk about every one of them, but you see some wetlands that are geographically isolated, have no connectivity to downstream waters, and so those are wetlands that would not meet the relatively permanent standard because they lack a continuous surface connection. So that's important. Okie doke. So I'm going to assume that gets us enough to move ahead. So still on the category of A3, tributaries. Tributaries meet the relatively permanent standard and are thus jurisdictional when, as we just showed, they have standing or flowing water year-round, or continuously during certain times of the year. And so that's language that you recognize. Continuously during certain times of the year translates to seasonal flow, okay? And so I added a note: tributaries that have standing or flowing water for less than a season are not going to meet the relatively permanent standard, and thus presumably those tributaries are not within Clean Water Act jurisdiction under the 2023 WOTUS rule as amended to conform with the Sackett rulings. And so stream flow in terms of duration for at least a season or permanently, perennially, are jurisdictional. Those that have less flow than that are not jurisdictional. We're not saying they're not important. We're simply saying that they're not covered by federal jurisdiction. Category A4 are wetlands, and in fact, wetlands that are determined to be adjacent to the previous categories, A1, A2, or A3. Reminding you that A1 are traditional navigable waters, A2 are impoundments, and A3 are tributaries. And so any wetlands that are determined to be adjacent to those previously described categories would then be jurisdictional as A4 waters. And so this slide's a little bit busy in terms of strikeouts and stuff, but I think it's really important to flesh this out. The final rule includes the agency's long-standing definition of wetlands. Yes. And so here, literally, we're showing you that the definition of wetlands that we've been using since prior to 1987. 87 is the date of the delineation manual that we all follow so carefully. That definition has not changed in many, many years, and it remains unchanged in the 2023 rule. So that's comforting, I think, and reassuring. But what did change, I think, dramatically is the definition of adjacent itself. It went from everything you see in the strikeout there to 7 words. And if you look at the little red arrow coming down, I've just thrown in this phrase here per the Sackett ruling. The amended 2023 WOTUS rule now says adjacent means having a continuous surface connection. That's the definition of adjacent now. And that's the definition, presumably, that the Corps of Engineers will implement in reviewing requests for jurisdictional determinations and permit decisions that are based on JDs that are issued pursuant to the 2023 WOTUS rule, as well as the pre-2015 rule, but which we're not specifically describing today. And so jurisdictional, I put that in parentheses because it's kind of redundant, right? If a wetland is an adjacent wetland and fits the definition of category A4, it is jurisdictional. So a little redundant, but adjacent wetlands include wetlands which are adjacent to A1, A2, or A3 waters. And you will notice that I've shown you, it's not in red font, but it is strikeout language. Some language that was in the 2023 WOTUS rule in January got struck by the Sackett ruling in May. So there you have that. And then the final category in the 2023 WOTUS rule is category A5, and this is intrastate, notice, lakes and ponds. Streams and wetlands were removed from this category because of the Sackett ruling. So now this category is literally intrastate lakes and ponds. And these are those waters, lakes or ponds, that were not identified in any previous category. For instance, lakes that did not measure up as a tributary or ponds that didn't measure up as a tributary under A3 could be identified under A5 if they meet the relatively permanent standard. And so, I guess if you're taking a look at either the couple photos or the little graphic description, of a wetland that has its own localized small drainage area and doesn't seem to have an outfall to downstream waters, you'd be looking at a depiction of a wetland that likely doesn't meet the relatively permanent standard because it doesn't have a continuous surface connection to downstream waters. And so that's kind of the important distinction for waters that would be jurisdictional under A5. So they must meet the relatively permanent standard, either standing or continuously flowing bodies with a continuous surface connection. So all of this is here, and certainly we're not reading every word because of time constraints and just keeping everybody awake. But as you take this back and maybe look back at it in time, you can read this more at your own pace and kind of take it all in. And so now a bit of attention to exclusions. We're looking at 1:39, so I think we're okay on time. Exclusions, as you saw in the beginning, there's 8 different exclusions. I'm going to gloss over most of them and focus on a couple of them. But many of these exclusions are longstanding exclusions from previous versions of the definition of waters of the U.S., and they remain in the 2023 WOTUS rule. Importantly, excluded waters are those waters that are waters or water features, but they're not waters of the U.S. by definition, and so they wouldn't be jurisdictional. Waste treatment systems is B1, prior converted cropland, longstanding exclusion, is B2. I didn't want to say much more about that, but I did want to say something about B3, which are certain ditches, okay, and then B7, certain waterfield depressions, because this could be something exactly like a borrow area that's either still active or that's abandoned and doesn't meet the rule, the definition of waters of the U.S. Maybe it's a borrow area that does not have any connection to downstream waters. And so waste treatment systems, including treatment ponds that are permitted by 402, for example, these they don't sever the concept of jurisdiction for upstream waters that aren't part of the system, but they themselves are excluded as waters of the U.S. So it's important to know. You probably do know that. And so waste treatment exclusions. And for ditches, and then also waterfield depressions, a couple of things to show. Two really different examples of ditches or canals. The two photos kind of show you the bookends of it. A very substantive ditch or canal that's got flowing water and or continuously standing water can be considered a water of the U.S. because of the relative permanence of its water, as long as it can carry flow down the landscape to an A1 water, either directly or indirectly. A non-jurisdictional ditch out there would be a ditch which either does not have the relatively permanent flow, and so you see a really dry ditch and a really wet ditch. There's lots of circumstances out there in the landscape that are in between those two stark, contradictions there, and they get evaluated appropriately on a case-by-case basis in the field. So one of the things I often encourage is that when systems, including ditches, are part of the waste treatment system, it's good to have that paperwork on hand when requesting a JD from the Corps so that you can demonstrate what ditches out there are part of the stormwater system and what are not, because that's important to the Corps of Engineers in making their determination of jurisdiction. The waterfield depression category, B7, you see here along Interstate 40, some former borrow areas that are now abandoned and yet have no apparent outfall to downstream waters. And so these are waterfield depressions that were created in dry land, that were incidental to construction activity, et cetera. And they are water bodies that do not meet the definition of waters of the U.S. After they're abandoned. And the definition part that they're probably not meeting is that connection, that continuous surface connection to downstream waters. And so on that basis, they're excluded. So good to know in the work that we do. And so a final couple of comments, and then we'll be able to open it up to whatever discussion anybody is interested in. And it's this, many people, after seeing the Sackett ruling and then the amended waters of the U.S. Definition, have these questions in mind. What is the future of wetland protection for many of the waters that are no longer covered by Clean Water Act jurisdiction? So we acknowledge right away that federal protection for certain waters and wetlands is likely to be substantially reduced. EPA and the Army will be very careful to follow the regulation now that it's been amended to conform with Sackett. And so they have diminished jurisdiction. But we do remind ourselves that some states have their own state level wetland protection regulations, and those will be increasingly important perhaps. Many states do not. Every state has the ability to create their own wetland regulations. And I guess it remains to be seen, down the road, whether some states will enact wetland regulations in their states or whether they won't. But these are all things that we're aware of and that we're watching, as we kind of, live through this most current phase of wetland and waters jurisdiction. I like to provide the reminder that for federal aid projects where federal funding is provided, Federal Highway Administration does offer reimbursement for mitigation. That's mitigation for federally jurisdictional wetlands, but it's also mitigation if the state DOT chooses to do so, for compensatory mitigation for non federally jurisdictional wetlands. And so, the regulations at 777 identify a goal of net gain of wetlands on a program-wide basis. And so, that's a nice thing to be aware of, and call DOT, your DOT's attention to the fact that reimbursement's available for that kind of mitigation when it's appropriate. And so I'll just leave it at this screen here, I guess, so that you can kind of get a sense of some of the relevant resources. This isn't exhaustive at all. It's just the high points that are part of what's kind of underpinning the discussion that I've provided today. So you can look at the rule itself and the preamble to it. There's a lot of great discussion in there, and then some other tools that are useful at your desk and in the field when determining what waters of the U.S. might be on a site. And then so I'll stop right there and be happy to join into any conversation that anybody's interested in. So